Air India flight took off from Ahmedabad for London, but tragically, just after the takeoff, it crashed into the BJ Medical College. This incident has a direct relation with the law because when such disasters occur, it is the law which determines who is responsible, what compensation is due, and how the legal system ensures transparency, fairness, and accountability in the face of such a huge loss, such an overwhelming loss. So today we will explore the law related to compensation in aviation accident cases. And our focus will be on the Montreal Convention of 1999, the Carriage by Air Act of 1972, and the most recent one, the newly enacted Bharatiya Vayuyan Adhiniyam of 2024. First is Montreal Convention of 1999. Now, this convention is applicable to international flights. And as per Article 1 of this convention, international flight or international carriage is that carriage where the place of departure and the place of arrival are in different countries. So this Air India flight qualifies to be an international carriage for the purposes of this convention. Then Article 17 of the convention. Article 17 of the convention provides that the carrier will be liable for death or bodily injury of any passenger if the incident occurs on board or during the process of embarking or disembarking. Now, this liability is strict to an extent. To that, I will come to later. What the compensation structure is, right? Next is the Act of 1972. Now, the Montreal Convention is part of our Indian law through this act. India ratified the convention in the year 2009, and by way of an amendment to the Act of 1972 in year 2009, the Montreal Convention is incorporated into the legal system, particularly by way of the third schedule. So the principles of compensation that are there under the Montreal Convention, they are applicable in the Indian legal system through this route. Then we have the Bharatiya Vayuyan Adhiniyam of 2024, which among other things provides the mechanism to determine the compensation and also the process of investigation. Right? Now let's understand how the compensation is calculated. The Montreal Convention provides a two-tier system for calculation of compensation. First, there is a strict liability. I have told you already. There is a strict liability up to a certain extent. Now, what is that limit? Strict liability is up to 1 lakh SDRs. SDRs are special drawing rights, and one SDR approximately today is equal to 122 Indian rupees. So up to 1 lakh, there is strict liability. Then for further liability, in case of further liability, if the claim is made beyond 1 lakh SDRs, then the airline can escape the liability only when it is able to show that the airline was not negligent and has taken all the necessary measures. So the burden lies on the airline, right? Same principles applicable to us through Act of 1978 by way of amendment in 2009. And these principles were clearly discussed in very detail by the division bench of Kerala High Court in the Mangalore air crash case of 2010. In this case, the court held that first there has to be an offer from the airline. There should be an offer from the airline, which is a reasonable minimum offer. This is to avoid prolonged litigation, and by prolonged litigation, nobody is a winner, right? Neither the airline nor the victims. Then, in case there is no settlement, then claim for compensation can be made. And then the High Court clarified that up to 1 lakh SDRs, there is a clear, strict liability that has to be mandatorily paid. Okay. Then Montreal Convention also allows for advance payments. The airline can make some advance payments as done in this case also. Now, these advance payments are not will not amount to admission of guilt, and they will be adjusted against the final compensation that will be awarded. Okay. Then we have before we part, I would like to clarify more things, not only related to the passengers that were inside the aircraft, but other victims. So let's talk about the crew members first. The compensation with respect to crew members, the pilots and other members of the crew, it will be governed by their employment contracts, and usually the employment contracts, they have insurance and indemnity clauses. Then with respect to the people who were not inside the aircraft but in that building or around that building, who have died or suffered loss, in their case, Montreal Convention will not be applicable. Montreal Convention is applicable, as we have discussed, under Article 17 if you are inside the aircraft. But these people are not remediless. Here, the tort law becomes relevant. Under tort, there is a principle that if a person suffers any loss or damage because of negligence on the part of the other, then he or she can claim compensation. But here the burden will lie on the claimant to prove that the other person, in this case the airline, was negligent. Next, I would like to highlight three important provisions from the Bharatiya Vayuyan Adhiniyam of 2024. These are sections 22, 23 and 24. Section 22 provides that compensation can be by way of an agreement, or it can be awarded by an arbitrator appointed by the central government. Then section 23 provides for an appeal. An appeal can be made against the award to the High Court. And section 24 grants the power of civil courts to the arbitrator for the purposes of this adhiniyam. Right? So the law cannot undo the loss, but it can respond, it can recognize this loss and can respond with fairness. That's all for this session. Thank you for watching it, and let reason and responsibility guide us all. Thank you again.